Yo, what is up? Brother Church on the air. Everybody coming through the door. Thank you very much for coming in. CH in here already. Talking about this AI Kohberger photo. Get the hell in here, hit the like. Let's rock and roll.
Let's rock.
Here we are here together on a murder church on a Tuesday night. Started a little early. Yeah, gonna just chill out here a little bit tonight and watch a little bit of this. Go back into what we were watching, I think Thursday last week, the Bryan Kohberger hearing, and we're in the hour. I think we've watched an hour, so we're going into hour 2 here. I think I'm in the right spot-ish. We're gonna see. Yeah, let's rock and roll here. Let's get her going. Pick her up a notch here. We'll talk to some folks as they come to the door. Let me hit the bells though. We gotta start out properly, even if we gotta do nothing else correctly here. Get the bells a buzzing, huh? You got me a brewski cracked. Ready to go.
I just can't imagine any reasonable person coming to such a conclusion. And certainly the jury will be instructed that they may not use that evidence as propensity, may only use it for the relevance of things like identity, ownership, and control.
Sorry, we have something in the Vallow case, Charles?
There are concerns that were raised, however, and so, well, as a concept, I think the video is appropriate under 404, or notwithstanding 404B and 403. I do want the video
coming through.
Potentially, I'll look at it, and it may change my mind. But just from the description, I am concerned about some of the interactions with the officer that was mentioned that, that Mr. Kohberger questioned.
Yeah, I think right after this is
something about how, and it does potentially create some unfair,
is when we left off.
Some danger of
I'm
unfair
not mistaken.
or unnecessary
Jen in the house,
prejudice.
welcome
So
through.
I think it needs to be redacted to exclude those kinds of things and have
No, I hate to hear you've been having some tough days. Hope you're doing okay.
video that shows his
Salty sleuths?
vehicle, that he gives the registration, that identifies it as his, that he
I am making my way through this very slowly, Salty. I know that you've probably already went through this entirely, but it is 8 hours. It's a lot, but I'm working through it.
Not the stuff leading up to what his telephone number is, but if he gives the telephone number, the answer, what the telephone number is. I think that's what we ought to see and probably not much else. So I'd like to see that before it's played to the jury, and you can work on redacting that and showing it to counsel, and within the confines of my rulings, they can raise any concerns they have.
Thank you, Judge.
All right, let's talk about who is going to be in the courtroom amongst the victims and the defendant's family.
I'm glad you're hanging out.
In terms of a reserved seat, I'm not as concerned about the reserved seat part. We can address that at the pretrial conference down the road. I'm more concerned about the ability to be in the courtroom, notwithstanding an exclusion order of the court of witnesses. So let's address that issue.
Your Honor, the state filed this motion in order to seek clarification of the court's definition of immediate family member pursuant to Idaho Code 1953-06-1B. As you know, that specific code section doesn't give us a definition of immediate family member. The state has given a proposed exhibit, State's Exhibit S1, which we think are justified as being immediate family. It's my understanding that defense has stipulated to that list, and we would just ask the court to issue an order to that effect. This takes care of the issue that the state raised. I don't know if you have any further questions.
Well, there
What's
is
up,
the
Ola?
issue of the defendant's family.
Tiff,
That's, I
thanks for
think,
coming
the
in.
defendant's motion, so I'll let them address that first.
So much.
The state submits that by simply placing our client's family on its witness list, that is enough to warrant exclusion, and further that
Yeah,
they
this is where we left off. So yeah, we're going to get into the family stuff with the witnesses.
may call family members. I want to note that they have not subpoenaed them, the state's attorneys have not interviewed them, and they know that Mr. Kohberger's family does not have any interest in helping them. They also know from watching all of Mr. Kohberger's video visits how much his family loves him and supports him, and that he is absolutely dependent on them, having been in isolation for almost 2.5 years, and by the time we get to trial, it will be almost 3 years. His parents attend every court hearing, and the only reason that they are not here in person is that they do not have the money to fly back and forth from the East Coast. If they had the financial resources, they would be here in person every single court date. Sequestration of witnesses under IRE 615 is discretionary. The language in the statute is that they may be excluded by the court. This means that there's court discretion in that decision, and there's a reason for that.
I can see the sister
The
or the
reason is that
dad.
the court must balance Mr. Kohberger's constitutional right to a public trial with other needs of the case. In the United States Supreme Court in Ray Oliver in 1948, the court stated, "Without exception, all courts have held that an accused is at very least entitled to have his friends, relatives, and counsel present, no matter what offense he may be charged." The Tennessee Supreme Court recognized the same precedent in State v. Sams in 1990. In that case, the prosecutor subpoenaed all of the defendant's family to keep them out of the courtroom. In reversing the case over this issue, the court held, the assistant district attorney's blatant abuse of the trial court subpoena power for the exclusive purpose of removing the relatives from the courtroom constituted egregious prosecutorial misconduct. The state action violated the constitutional right to public trial, as well as the constitutional right of the relatives to attend the trial. In a more recent case in Iowa in 2022, State versus Bremer, a conviction was overturned when the accused family was excluded from trial due to COVID-19. The court pointed out even the defendant's mother was excluded. The purpose of the witness sequestration is to prevent a witness from tailoring his or her testimony. In this case, all of Mr. Kohberger's immediate family were interrogated in the middle of the night when he was arrested. All of their interviews are videotaped. There's no tailoring
We
of
get to see any of those videotaped interviews with the family from that night.
testimony to be done.
That will be
Add
interesting.
to that the evidence
God, I
that
can't
the
wait to see what all
defense
actually
has
gets
disclosed to
shown in the
state
trial.
in discovery, and expert opinions, which the court has had the ability to review. Those provide an even more narrowing, who it would be even rational probably for the state to actually call. At best, there's one potential family member that they may see a reason to call. The state knows that Bryan's family has no desire to be used as witnesses against him.
Forget book club
From
immediately
the
after
minute
this, guys.
this trial begins, the jury is going to
Members only
study
book
Mr.
club.
Kohberger, and they are going to figure out who is in this courtroom sitting behind him to support him. Weeks into the
See the
trial,
crazy lady with the twisted T ain't showed up yet.
the jury is going to know who's in the gallery. That's why
Throwing up the
there is
hearts.
a
I know, it's crazy.
constitutional right to a public trial. So that what happens here is not done in a star chamber. And for our client, the jury will know that he has people there to support him.
Yo, Cat.
Mr.
Oasis
Kohberger
Cat.
needs his
Nice, getting ready
family
for book
to
club. That's what I
support
like to
him.
hear.
As the court knows, we have several motions.
So Jersey Jen coming through here real quick. I see the crews come through here. I appreciate it, guys. Thank y'all very much. Jersey Jen, glad you're here. Glad you're hanging out. Fucking beautiful, wonderful lady. Fucking rules. Absolute G around these parts. And gifting out a membership here that also, of course, gets you on the wheel, baby. What kind of wheel is it? Physical. It's a physical wheel. It's literally a physical wheel. Woo! So Jen, let me get you on here. Also, who got that motion granted? Who now has the opportunity, if they are hanging her out, for the members-only book club portion of the Tuesday night party? Pretty cool. Pretty cool. I read my chapters today, or listened to them rather. Chapters 10 and 11. The Stranger Beside Me. And yeah, we're in the middle of working on another wheel right now. The Buzz Nation coming through. Again, Jen. Again, G around these parts. Let me get you on here. Boom. And we are 4 people currently on the wheel. So pretty freaking cool. Since I got a couple of people in here right now, we got a cool weekend coming. Friday night, Feral Friday. I got Chris DeWitt coming through here. He was in the chat here earlier. Fucking the man. Going to be a really cool pre-420 show we're going to be doing. I'm not sure what we're watching just yet, but I'm excited to get into something. No, I've been thinking about some stuff. I'm going to talk to Chris also. But then Saturday, make sure you clear off your calendars for in the afternoon, 3 p.m. Eastern. Jay going to be coming on here for the first time in a long time. Dandy Savage is going to be joining us, and we're going to be having a pre-420 show on that day as well, folks. And I don't think there's going to be a Murder Church on Sunday, but having those 2 heavy shows are going to be pretty special. So again, thank you all so much for just being dope as hell. Love it.
That we will be addressing regarding his autism spectrum disorder. He needs to have his family here to support him, and they need to be in the courtroom supporting him. These needs are constitutionally protected rights. We ask that you enter an order making it clear that the state does not get to put his family members merely on a witness list and keep them out of the courtroom. If they want somebody in court, there needs to be an out-of-state subpoena issued. They need to provide witness travel funds to be here and make their intentions very clear. And then this court, we ask, exercise its discretion and allow whoever of those family members the state may actually subpoena to be in the courtroom, because there's no need to worry about how they may tailor their evidence.
That's the guess,
because
baby.
It's their testimony.
I could have put Dandy
because
in there.
It's all video recorded.
Hold on.
And
boom.
The court could
Boom.
also order the
Boom.
state
Boom.
to make it those witnesses, if they do intend to call them,
trio
immediately call
quadruple right there.
As witnesses early on in the case, so that if there is for any reason going to be exclusion, that exclusion would be there for a very short period of time. But we do ask the court to consider how important in opening statements, when that jury walks in and they're making that immediate first impression assessment, how important it will be for Mr. Kohberger to have his family sitting behind him. We've also asked in our motion that the court address decorum, since the court's going to be issuing an order. As we pointed out, there's been some history in this case with clothing being brought into the courthouse that's pro-death penalty and pro-firing squad. There's no place for that in this courthouse at all.
That would be insane. The judge just like, actually, I think that I'm going to allow that. If anyone wants to wear a shirt or, maybe just depicting Bryan Kohberger being blown away by firing squad, I'm going to allow it. I'm going to, sure, fine. You know what? I don't.
These proceedings. There's no place for that in this courtroom, and we
Gabby.
ask that the court issue an order that spelling out very clearly that that will not be allowed. Thank you.
Oh man, that's true. Yeah, Miss Dina sent me that. Frog, what's up?
Your Honor, the state trusts that this court will enter your own standards of decorum for the courtroom, and the state will advise our witnesses and immediate family in accordance to those instructions, and we expect that they will be followed. Regarding the defendant's family, in no way is the state intending to use its subpoena power in order to exclude Mr. Kohberger's family from the courtroom. The state's not aware of any authority to support this argument that the defendant has a Sixth Amendment right to have his family in the courtroom. He, of course, under the Sixth Amendment, has the right to a public trial, but that's not his choosing of who is in that courtroom. Totally understand it's within your discretion to allow certain immediate family members
Okay, I think I do remember seeing
in the
something
courtroom
about
to
that.
support
The
Mr.
reason you
Kohberger.
can't simply take up whatever family members you may need to testify. in
Gabby,
case in
coming
chief.
through. $3. Let's go. Holy
Other-
shit. That's insane. $3 highlight coming through. Let's go. Let's go. Shit, Gabby, getting us up there. Just another level to the wheel. Let me get your name on here real quick. Boom. Appreciate that. Thank you very much. Gabby's always posting the most delicious looking food I've ever seen in my life in the Discord. Insane. What's up, Heather? Welcome in here. Get in here.
Narrative on how you want to lay these things out, but what I will tell you is both sides ought to get used to the idea
Oh,
that
shit. Jersey Chin just
with
said,
the 3 months
fuck everybody. Fuck everybody. I want some tattoos, bitch. Yeah, that's right. We got tattoos that you can put on your body. We got magnets, Murder Church magnets, of course, as well. And then lots of other dope stickers and trinkets that are going to be on this wheel. Jen coming through again with a $2 holler. Book club tonight if you aren't a member. That's right. Immediately after this, thanks for the plug. We're going into the book club, Buzz Nation Book Club. We've been reading The Stranger Beside Me, Ted Bundy book by Ann Rule, who worked with Ted Bundy in 72, I believe it was, at a crisis call center. And yeah, the book's getting interesting. We're about a quarter of the way through right now. And we just read chapters 9 and 11. But all past episodes from the members only book club are accessible if you're a member. So, and there's very heavily detailed notes that I go through every episode, and tonight will be no different, folks.
month trial, the trial schedule will not be
Super
held
interesting,
hostage
too. I'd
to
never
your
read that
narrative.
book and always wanted
In other
to.
words,
And I got a
we're
reason
taking
to.
things out of order, stopping witnesses to put another one on to make sure we get them through them, and picking them up again. And so,
That's right.
is there a reason you couldn't call whatever family members you need right away?
Well, I will say, we have no intention of calling all the family members. We have the intention of calling a few of the family members who serve certain purposes. I can't think of a reason that we couldn't. Obviously, it's not ideal. It's completely out of context. It's out of order.
This is like a gumbo. You are going to put all the pieces that go into that into the pot. And at the end of the day, the jury's going to decide whether it's a good soup or not from the state's perspective. And so I think we get too obsessively stuck on the idea of exactly the order these things need to come in, right? And so I'm not sure why you couldn't call the family members you need up front, and then we take away this concern. I can certainly understand from the defense perspective the need and desire to have the defendants support family here in the courtroom.
I do too. And
Abby,
I guess my preference would be
yes,
for
thank
that,
you.
even though it would be out
$3.
of context and interfere
Filling these
with the
pockets
state's
for the weekend. 420 is about. I'm looking for them
preference
deals.
of how to present its case. And I think I do take issue with
thank you
the
so much.
defendant being able to direct how the state presents its case to
$3
a jury.
holler.
However, if our options are the immediate family members staying in the courtroom and hearing all the testimony of other witnesses versus calling them out of order, it would be our preference to call them out of order. Thank you.
Judge, I knew that the state's position was that there's no case law to support our position, which is why I just went through several cases where it is his constitutional right, one, for it to be public, and there are cases, as I referenced.
constitutional right is not absolute and bends to, for example, rules of evidence and other rules. And I'm not aware of anything that says that court can't use the exclusionary rule where in good faith a person who was otherwise entitled to be there, including family members, have to be excluded for some period of time.
And that is why I specifically talked about the point that it is discretionary for you. And there's also, Judge, a level of humanity that I hope that you take to serious heart for his family, who is absolutely devastated and dealing with things like headlines that they're going to be called to testify against their son with these types of communications that are happening. And so we're asking that you use that discretion and that you find that humanity. Thank you.
Thank you. I'm going to take this matter under advisement. The defense
One of the
raised
ones he
some
took under
cases.
advisement,
I want to
which
read
you know,
those.
just reading. I remember, which we started last Thursday's show with going through the Fox News
Though
thing,
they-
and
I
it's pretty
don't think they
detailed.
were
But
precedent on this court setting.
some things he didn't rule on the
I
state,
have
of course.
reviewed the U.S. Supreme Court opinions cited, but in terms of other states, I'll
Girl
look at
Friday,
those.
I haven't announced that yet, Gabby.
do
I actually haven't
think, and
announced
I'm
Saturday's movie
asking
yet
the state
either.
to think about
I could do that right now.
to use counsel's word, the humanity. I think that
Yo, Debbie.
you know,
What's
I
up, Debbie?
can only imagine the family of Mr. Kohberger is devastated by these things. That's nothing that they did. And I think their ability to be here to see the trial is important. And to the extent possible, while also preserving the state's right to a fair trial, should be something that we seek to do. And I think calling them out of order is one way. Now, I know that there is, I don't know why the state would want to call them. I haven't, reviewed their interviews. I don't know anything. I do know there's been an issue raised by the defense relative to purchases on a alleged family account that could be an issue. And so I do see some issues where family members may be important. And so I think there may be some need for exclusion, but I think the best way to handle that is to get them on and off as quickly as possible at the beginning to
Oh,
deal with
dude,
that.
same, Debbie.
I'm
You
reserving
know they
ruling on
hate
that.
it.
I want to look at it. and I will
He's
issue a
so
written order
thorough.
on that.
And he just really tells
in
what's
due
on his
course.
mind. He's not bullshitting about nothing.
All right, let's talk about the defendant's motion regarding conditions as an aggravator, and this is the concern about using the defendant's alleged autism disorder diagnosis as a aggravator during the penalty phase of the trial, if there is one.
Thank you, Judge. You summarized exactly where I was going to start. This motion is brought in case there is a penalty phase. If there is a penalty phase, Mr. Kohberger has a right to present mitigation evidence. That is State versus Payne, and Roper versus Simmons tells us that mitigation evidence cannot be used as aggravating evidence. This is something that we talked about several months ago when we had our motion to strike the death penalty and ask for trifurcation with the death penalty, and that was denied, but we're bringing it back up because it's really important to make a distinction between things that exist in this case, Mr. Kohberger's autism, something that he didn't ask for. It's a condition that he has, and it'll need to be addressed. but also to prevent the state from using his characteristics of autism as aggravating evidence against him. The state has, and the court has, our expert analysis from Dr. Orr that talks
Bambies?
about how autism
Popping
manifests
in,
in Brian, the things that people might see.
Not much. We're
And
just
these are
hanging out,
things
getting ready for
that
book club.
we've read a little bit about in the media over the course of the case. Brian's physical body is more stoic, how he sits in one place. And he will look for a long time. Sometimes he'll hold his hands in a rigid position. And that means nothing. That's just how Brian is. We seek to prevent the state from using those kind of characteristics against Brian. We seek that in the way of testimony they might
Yo,
bring.
Bonnie.
Sometimes Brian will talk longer than maybe other people want to listen, and that doesn't mean anything.
I
That-
assume he's not going to be talking in court unless he's testifying, so.
That's exactly right, Your Honor, but that doesn't stop the state from bringing a witness and using that as aggravating
months.
evidence against Mr.
Damn right.
Kohberger, and that's what we don't
Damn
want.
right.
We want to be able to present, if we get to a mitigation phase, his autism and how that works and how
Thank you.
he's learned to
Thank you,
live
Gabby.
with the
Appreciate that.
conditions that he has and to prevent the state.
It's not the
Reading
smartest
the
move,
defense's,
Phil.
pardon me, the state's response, it doesn't sound like they disagree with you that it shouldn't be used as an aggravator. And so I think that in terms of what counsel's arguments are, we can control that. I think apart from a jury instruction, I'm not sure what we do with, how we deal with that with the jury in terms of the penalty phase, right?
Yo, left on.
If you
What's
present
up?
evidence of the
Welcome in her.
disorder.
Your Honor, the court can do what we've requested and prevent the state from using Mr. Kohberger's conditions of his autism as aggravating evidence. I think a jury instruction helps the jury to understand how to use mitigating evidence. Our purpose here is to ask the court to take the step of an order. I don't think the state opposes it.
What would that order say?
That order would say that the state would be prohibited from using as aggravating evidence Mr. Kohberger's autism characteristics.
How would they use it as aggravating apart from arguing to the jury that, well, because he has this condition, it means that he is, I'm just making this up, obviously, is
Inclined to not follow the norms of society and presents a greater danger or something like that.
Your Honor, the order would prevent the state from, on the front end, in presenting their aggravation case, from using the conditions, the way autism works for Brian, against him, to say that he does things that are consistent with autism and that that's an aggravating circumstance.
I'm just having a hard time envisioning what that would be, how it would be presented in a way that is making it an aggravator.
Well, I would hope that it wouldn't be presented that way. But, Your Honor, when I look through the mounds of discovery, there are probably 100 hours of interviews of people that Mr. Kohberger went to school with at WSU. And of course, those interviews come just hours and
How many
days
people in these
after the
interviews are gonna
headlines
say,
hit that
"Man, he
Mr. Kohberger's
fucking
been
sucked,
arrested
dude.
in this case.
Loser.
And people that he went to school
Weirdo.
with, that he interacted with,
This
had
fat fucking
unkind
guy?
things to say about him. And a lot of their unkind things, when you understand them in the context
The
of
dude that stalks
autism, the way
girls?
he may stand in a room near a doorway, the way he may look too long at a person, their interviews
Reading this Bundy book.
are
He likes
different
this. There's a
when you know he
some
has
staring in this
autism
book.
and you know the
Ian Rule-
characteristics he
Ian Rule is
displays.
probably putting a
But
little bit
those
of
awful
extra
comments,
emphasis
those
on some of these
mean
situations that
comments
she's
about
talking
him,
about.
if the
But
state uses those
talk
as
about this Bundy
aggravators,
glare.
that's using his autism characteristics.
How do I, though, and I don't
I'm
know if
just-
this
I'm
is
just
a real
bullshitting
thing,
now, you're
right, in
not.
terms of actual evidence. Let's say there's evidence that he harassed other young females. Okay, and I'm aware of no evidence in that regard. I just want to make that clear. I'm just using this.
Whoa. The judge is saying this is just randomly, like, that Ann Taylor and the team hate this. Holy shit. Even the judge just spitballing here a little bit. Let's just say he was a creeping.
This is an example.
Just an example.
And let's
all calm down.
assume that in and of itself is somehow relevant to in an
Yes,
mitigation
immediately
aggravation
after
penalty
this.
phase.
Like 30 minutes.
Your position is that's due to his spectrum disorder, whereas the state's view no, that's not. That's
Tip thinks he's creeping.
his view of women and goes to motive, etc., and goes to his aggravation of the crime in some way, not because of Asperger's, but because of his views, his dislike, and how he responds.
That's exactly the problem, Your Honor. If the state, and
Do you want
I
me to,
wanna
you want
be
me to weigh in and
clear.
say what the factual findings are, that it's this and not that? And I'm not sure I can do that as short from a jury instruction that, you cannot use mental health conditions as an aggravating factor.
that's an appropriate jury instruction, and if we get to that phase, my guess is that we'll have one of those jury instructions. But if it's an appropriate jury instruction, how is the jury to understand and properly respond to that instruction if the state has been allowed to run over the top of that during the presentation of their aggravation case? It's that I want to limit. Once we present
There
mitigation,
may be a dispute about the reasons for his conduct, a factual dispute. And that then ultimately is for a jury to determine, not for me.
Your Honor, I believe the court is envisioning a problem that does not
I
exist.
hope so.
I think that the court will not find that comes up.
The judge
I
is
think
saying,
the court
I think
can
that's
issue an order
what you're
to the
talking about
state
here, a problem that doesn't
that would be
exist.
not to use his conditions of his autism as an aggravator, his diagnosis of autism as an aggravator. That's going
Dude,
to
Santa's
be
coming
very
after
similar
Kohberger
to the
hard.
court's jury instruction, and that
Swift.
keeps the trial process clean, and it allows the jury to draw the distinctions and properly use mitigation as it's
That's
supposed
pretty much
to
his
do.
stance on
This
most of
is
their
a
stuff.
protective measure to be
Yeah,
sure
he tells them.
that case law is complied with and that Mr. Kohberger's
Like,
constitutional rights are protected.
Is it though?
Thank you.
Yeah, he said the fuck down.
Morning, Your Honor. So the court is correct that I don't think there's a whole lot of room between the state and the defense in terms of what the law says here. But there are maybe some practical problems in what the defense is asking for from this order. And the court has already nailed this, if the court is to issue an order that says the state can't rely on his autism as an aggravating factor, then anything we try and present, they're going to argue, well, that's a symptom of his autism, and therefore the court's order says you can't use that. I don't think that's an appropriate approach. What I can tell the court is the state has no plans whatsoever to use the autism during the penalty phase as any kind of aggravation whatsoever. There is no plan to put on
Baby.
students from the university to talk about their personal views of this individual.
The hell out of
To be
here.
quite frank, if we get to a penalty phase, we have a lot better aggravating evidence than the fact that he has level 1 autism. And frankly, it's just not a persuasive argument to ask a jury to impose the penalty of death because someone has autism. So from the state's perspective, this falls largely into one of the categories the court mentioned earlier in a different motion, that it's just really not necessary here. We understand the law. We understand that we're not to use his mental condition as an aggravator. We do, however, reserve the right to present argument as to if the defense chooses to present it as a mitigating factor, how much weight should the jury give it? And I think we have quite a bit of flexibility there to put on our own evidence as to what exactly this autism means. And so that if the defense tries to say this is the reason that you should not sentence him to death, then we should be able to argue this does not make up for the proper aggravation evidence that we've put forward. I think not only is that the state's right, it's what the statute requires. It's what the Idaho Supreme Court has been very clear that a juror in this situation has to be able to do. It's their duty. That was the Dunlap case. It's their duty to weigh the evidence, including any mental health or mental illness evidence, and make that ultimate determination. And so the state does not believe that this order is necessary or appropriate, but also has no plans of using this as aggravation. Thank you, Your Honor.
Response?
We understand that
You are
the
forgiven, my
state
child.
can argue the weight of the mitigation evidence. That's not why we brought this motion. As far as
Yippee-ki-yay, motherfucker. This is gun country.
what the conditions of autism are and the way it works in Bryan, the state has received through our expert disclosures reports that describe that. So there's some guidelines for the state there to understand what we are talking about with Bryan's autism. The state will present its aggravation evidence first.
Shelly
The
coming
protective
through.
order that we're seeking from the court, the order to say you can't use his autism and the conditions thereof in your aggravation case, is easy, it's protective, and if we get to a penalty phase, it is imperative that we protect the rest of the trial. Certainly, if the state thinks it needs to present something in aggravation and there's a question, they could ask the court to revisit the order. This is just a very good, clean way to protect Mr. Kohberger's constitutional rights, and we ask that you enter an order.
Thank you. Right. I don't, again, from a legal perspective, I don't think there's a disagreement about the use of the autism spectrum disorder as an aggravating factor in the penalty phase. The state certainly shouldn't make those arguments and are instructed not to do so. But how that comes up factually, the fact that your expert says that this is one of the symptoms of this, that the state can't put on some
welcome
evidence
in.
that they may disagree about, I'm not in a position to make that sort of blind statement or blind ruling. I think we need to get closer to trial and see specifically what we're dealing with. And so I'm not inclined to issue such a broad order in terms of
Don't forget book club immediately
the
after this,
actual
folks.
evidence,
Just coming
the
through.
presentation of evidence. I think I can certainly say don't
Trying to
make
start
that
up probably about
argument,
9, little after 9 tonight.
that the fact of the diagnosis is somehow an aggravating factor. And we can deal with the
Trying to put another hour
symptomology
into this
that the defense
Kohberger
contends
deal
is
here.
part of the diagnosis that the state may take issue with or believe that there's some other relevance of in the penalty phase. And so we'll deal with that on a case-by-case basis as we get there. So the extent of my ruling is simply that the state should not make the general argument that somehow the diagnosis is an aggravating factor. All right. Why don't we take the morning break? We'll take 10 minutes and be back at about 20 till. All right.
A little bit more
Let's
here.
talk about what I hope we have come to an agreement is not an issue, which is the IgG stuff.
Oh, God.
If I may
What do you
start
got, a
with
couple of
the-
hours? You got 3
I
hours?
think there are 3 motions. One is
Jeez.
the improper expert testimony of Middleman, who's related to the IGG. And that's a defense motion regarding IGG evidence generally, and then the state's motion regarding IGG.
Yes, good morning. You're right, Your Honor,
All
that
right, some
we have
IGG
essentially,
talk.
I think, an agreement with the state as to their position and our position being equivalent at this point for different reasons. And I believe that the state is willing to proceed without Dr. Middleman, therefore making that motion moot, and that they will proceed with using the generic term or the generic evidence of a tip leading to the identification of Mr. Kohberger. The only issue that we have is how that tip will be presented to the jury. The one thing that the defense is concerned about is exactly the testimony and the witness who will be testifying to the tip. And we want to make sure that nothing that is said by that witness implicates another source. And by source, I mean someone like a witness who called with a name or some other way of identifying Mr. Kohberger by name as the possible suspect. The state, in their response to us, said, well, we have lots of other evidence, and they have lots of other evidence they intend to produce. But the only thing that identified Mr. Kohberger that set them on a train or a trail to charging him was the genetic genealogy. So we just asked.
Well, I don't know if that's a fair statement. I think the thing that led to them investigating him was the investigative genealogy. I don't think that's what led to, the only thing that led to charging him.
I apologize. You're right. It was what they led them to investigate him and ultimately charge him. But I think that the court could issue an order or at least require the state to make a proffer exactly how they're going to do this. The reason I'm here is because I've done a lot of cases with DNA evidence, and the last thing I want is a repeat from a case I tried many years ago, which was a cold hit, where the state simply introduced a quote tip through testimony of a police officer, and the first question the jury asked was, what was that tip? And that is not, we do not want the jury to speculate. It's not our job to tell them how to do that, but I think the court has to be vigilant.
Well, I certainly could anticipate that being an issue in terms of the jury's curiosity, right? Depending upon how compelling or not compelling the other evidence may be viewed by them. And so it may be that you want to come up with some instruction to the jury that basically says, you know,
What's up,
we're not going to
Julie
tell
Mouse?
you what
Welcome
that
in
tip
here.
is, and you don't need to consider it
It's a
or
new
something
name,
like
I
that.
think. I believe.
Is that an invitation?
It's an invitation for you, two sides, to work together to try to solve this conundrum in a way that you both can live with.
Okay, well, I accept that invitation, and I assume the state also will be willing to do that. I don't know if anybody has any comments?
I mean, we see this sometimes, not in the context of DNA, but we will have, as an example, a probation officer who does a home visit and searches somebody's property without a warrant or other right, because they have that ability on probation, because the defendant will have waived their Fifth Amendment rights as a condition of probation. And sometimes we'll have to have the probation officer testify in a way that doesn't necessarily tip the jury off that the defendant was on probation, which would be a 404B issue. And I have seen, without some explanation to the jury, when we use those sort of generics or whatever regarded the search, that can cause curiosity with the jury and they can get sidetracked. And so we will frequently use an instruction to the effect of, law enforcement's search of the backpack has been found to be lawful, and you should not consider or concern yourself with that. Right, and so it's basically telling the jury, don't speculate about this point or how we got to this point. It's not important, and you're not to do it. And I think that generally causes them to back off that. And so that's what I'm suggesting that you
Okay.
try to work through.
Okay, will do. Thank you. That's all I have to
I
say.
didn't mean to cut you off. If you have
No,
anything-
that's all I have to say. That was the only concern that was left for us.
All right, thank you.
Judge, I think that fairly states where we are. I was curious what the defense meant in their reply where they said that the testimony about the tip should not falsely suggest other evidence. And
Bambies, that's
still have no idea
sounds
what
like
that
the end
means.
of a
But we are
Dawson
happy
and
to
Crypt
engage
show.
in discussion about
the very
a
end.
jury instruction.
She's
the
like in
court
front of the
outlined.
judge.
I
Zooms in
will
on her
comment
face.
that
Sorry, Judge.
it seems like it took a long time to come full circle because we're right back where the state started a long time ago with a lot of court effort invested in dealing with hearings in the interim. I appreciate the court's diligence with that. And I think also for the record, there were some pretty serious allegations, ethical allegations made by the defendant in its motion in limine number 11. Those were factually rebutted very clearly in the state's response, and I just want the record to reflect that the state maintains we did nothing ethically wrong with this, but we're satisfied with where we are right now.
Well, you know, sometimes we litigate issues for purposes other than evidence at trial, right? We do it in terms of constitutionality of searches and other things, and that's all okay. And I certainly have not made any finding that the state has done anything inappropriate, and so nor have I seen anything to suggest to me that that is the case as of this moment right now, at least, as it relates to that. To me, this is a practical problem, regardless of the reasons you are in agreement. The important part is that you are in agreement. I suspect what the defense is suggesting, I think,
I didn't
trying
hear
to read
nothing,
the tea
Gabby.
leaves, is
What happens
they don't
in the
want
Buzz Nation
an
stays in the Buzz
implication that
Nation.
there was
That's what I heard.
some
Snitches get
other
stitches.
evidence related to a tip or specific to Mr.
I'm telling you like it is, baby.
Huh?
Oh, shit. Here we go again.
Huh? I don't know nothing.
Oh man, I shot Marvin in the face.
Why the fuck you do that? Hold up. Hold up. Hold up.
Tina coming through the door. What's with Tina?
Kohberger that put him on the radar, right? And so I think that's just where you need to come. I don't think with those purposes we're suggesting that the state can't present its evidence about the car, suspected car, about the
Book club. Members only book club immediately following this at about
defendant's
15
whereabouts
minutes.
on the night, et cetera. Those are
15-minute
things that were
warning.
discovered
I got
and
notes.
put together
I got my notes.
after the fact, right? I think it also it is
Chapters 10 and
important
11.
to develop a narrative that doesn't suggest, for example, there's some fact witness who may have heard a confession from the defendant or have witnessed the defendant that led to the tip, right? And so I think it's important how that's presented, and hopefully you can work that out, and if you can't, we'll revisit how to address it.
Yes, Your Honor, I appreciate that. And the state's intent, we've already spoken with the investigators to develop this, is to have probably Detective Payne, who is one of the leaders and the lead investigators, to simply testify that they've received a number of tips, that around December 19th, they received a tip. Following that tip, they took these steps. That's what we're contemplating at this point. Thank you, sir.
And so we have a pretrial in next month, and so hopefully you can come to an agreement on how this is going to be handled specifically by that time.
Yes, sir. Thank you.
Anything to respond to, Ms. Barlow?
No, nothing on that.
All right, thank you. All right, that leaves
And like, you did a
category
terrible
A by
job.
my.
You did nothing. You were
score
so
sheet,
intimidated by
alternative
Heffler. You just shut
perpetrator
down.
Evidence, which is the state's motion limiting.
He really does command the courtroom. I care what everybody says. Whether you like the style or not. Jesus Christ, holding it the fuck down, son.
Oh, I didn't see that.
I forgot. That's what he said. Which one is this part? Bill's like, I'll come back up. Let me move back into position.
Thank you, Your Honor. And this is actually a very
Trimmed up my
convenient
beard just for
transition.
this.
We're looking at the history of this case and investigation. Of course, we, the investigators, and the state went probably some 6 weeks following the homicides, and during that time received thousands of tips and tried to substantiate or discount whichever we could. Where we ended up is the investigators were unable to substantiate any tips until they received the tip regarding Mr. Kohberger itself. The state's concern in bringing this particular motion is that the defendant is going to try to offer alternative perpetrator evidence based on what we would call mere inferences that another person could have committed the crime, and the case law in Idaho says they clearly can't do
So
that.
for purposes of your motion, are you talking about the defense's allegations of specific individuals? I mean, obviously, the defense claims the defendant didn't do this,
Yes.
which would suggest that there was an alternative perpetrator.
Yes. And the state's concern is about the defense focusing on specific individuals without making a threshold showing of connecting that individual to the homicides itself. And our concerns actually are reinforced by the defendant's response to our motion. When we're looking at pages 2 and 3, at the bottom of the page, the defendant says, "This case is full of alternative perpetrators. There are many alternative perpetrators." That suggests to us that the defendant is going to shotgun any variety of people's names, and we think that they can't do that without making the threshold connection first. Based on the case law, based on rules of evidence 401, 402, and 403, State versus Meister is the most applicable case. We're seeking an order prohibiting the defendant from offering specific alternative perpetrator evidence without first having an offer of proof to the court that specifically connects this third party, this alternative perpetrator, to the crimes themselves. And then we would also ask that the court set a reasonable deadline for the defendant to give the state and the court notice, make their offers of proof so we don't have to encounter this in the midst of trial, that we can prepare adequately for it. So that's the nature of the state's motion, Your Honor. Thank you.
That's all.
Your Honor, we do, as the state indicated, plan on providing offers of proof regarding alternate perpetrators. There's nothing about our approach that would be a shotgun approach, throw a bunch of spaghetti at the wall and see what falls. We understand that it requires the conditions of Meister and that we need to provide that information to
what's
you.
up?
We are still in the process of doing investigation, as you know, with the
Getting ready for book club.
amount of evidence in this case, and there's been a lot of briefing. There's going to be a motion argued about that. We are working as quickly as we can to put pieces together that make sense under the terms of Meister to present to you for that consideration with an offer of proof. So we understand the obligations. We won't be taking a shotgun approach. I would hope that the court would see that we are calculated and thoughtful in everything that we're doing in this case, and we wouldn't treat alternate perpetrator any other way.
We're moving right along here.
I don't believe the state has anything further on that point.
All right. I think the parties are both correct in that State v. Meister is controlling here.
I think all of these could be boiled down to don't fuck
where
around.
the court has spelled out that if the defense intends to present specific alternate perpetrator evidence, they have to make a factual showing that would, in fact, connect such a person rather than just throwing names out or arguments or theories out without evidence to support that I don't want to do that at trial. I think that's not enough time for the state then to investigate that. And I don't think it's enough time for the court to respond to that. And I think we'll waste a lot of time where we are not having trial as a result. And so what I would like to do is to look at a date shortly around the time of the pretrial to hear those proffers and go from there. Now, things may, I'm not discounting the fact that things may unexpectedly happen after that, but in terms of what we are or should be aware of at this point, I think we need to flesh that out.
Boo on the work,
before we,
though.
Go down that road. And so I will.
Thanks for coming in here tonight, guys.
Probably
Don't forget,
reach out
book
with your
club
calendars
ahead.
and set a date sometime.
If you ain't in the book club,
around that pretrial,
get in there. Member up.
Maybe even during that pretrial, since
Click
you're
on
here
that link.
to take
Get
care
in
of
there.
that.
Buzz Nation.
Thank you, Your Honor.
All right. And I want to be clear, I don't view Meister as controlling. For example, I know this defense has suggested that they believe the evidence suggests that there was more than one perpetrator. From presenting that sort of generic, unknown, unsub.
He's very clear.
Part of the craft involved. But this relates more to allegations of somebody more specific, identifiable.
I mean, it's almost like they write these motions before the hearings that we read. And then once they get in front of the judge, they're just like, oh, yeah. Oh, damn, did I say that? Me? Did we say? It's all good. No, they're doing exactly this. Everything's cool. As soon as they're back out, and after these hearings in front of a freaking judge where they could say something.
Let's talk about
dude. The difference between Judge and Judge Hippler is insane. Like Judge was, I mean, he was. I don't know. People didn't like him either for some of his rulings, I guess. But man, he was way more lenient in the way of kind of at least hearing out all of the defense's theories in detail. One of his tactics or lack thereof that he didn't do that Hippler does is always interrupting. I liked him also, but man, Hippler is interesting. He keeps you on your feet. I feel like it could get a little bit spicy,
which is
during the trial,
inconclusive data, the statistical analysis, and the reference to touch and contact DNA. Let's take up the first two, and then we'll take up the third. I think the first two relate to the same thing to a degree. In terms of the science of statistics and probabilities and all that. There are really three issues, as I understand it. One relates to how to convey.
Glad you came in here. Got some big shows coming Friday and Saturday, guys.
The statistics.
Friday is a pre-420. Saturday is a pre-420. Got Jay coming through. Chris DeWitt coming through. Danny Savage coming through.
Comparisons to, for example, planetary population. The second deals with
100% agree.
DNA that was found under one of the victim's fingernails and by the DNA analyst as to whether or not Mr. Kohberger could not be excluded. And then the third really deals with more sort of this labeling problem.
Completely different.
We've already addressed in some fashion.
They just shut
different
down
context of what labels can and must we use as it relates to the quote unquote touch DNA that was found on the knife sheath.
Yeah. Yes, thank you. That's a great summary. And I'd like to start with the first point that the court noted, which was motion in limine number 14, which was the relationship of the world population to the statistic generated from the sheath evidence with Q 1.1. And I think we are in agreement that the state is not going to address that kind of question in front of the jury because their own analysts during the grand jury essentially told them that you can't do that given the statistic that we have generated.
I understand the state's response is that they will present the testimony consistent with the way that the witness presented it at grand jury.
Correct, and it was my
Not
understanding.
in the way in which the question was asked that the witness sort of corrected the attorney about.
Correct, and the objection from the defense was simply, and I think the witness explained this very well, was that the statistical analysis that the state's experts have engaged in does not allow that kind of comparison. It's not the standard statistic that we're used to anymore, and so by asking that question, you're triggering, you're conferring, or not conferring, you're speculating essentially, put in front of the jury. It's a question that presents a false premise to the witness. And so we just ask that the state refrain from that and simply ask the questions that elicit, the
She's
the
so
testimony
nervous,
as
bro.
laid out in the grand jury
Hitler's like
proceedings.
Darth Vader, y'all.
Okay.
Tell me I'm wrong.
Excuse me. The
He's
inconclusive
choking her
data,
right now
I don't
with
know if
his
the court has
mind.
seen that late. I apologize. All of a sudden, my voice is
All right,
just
we can get you some
disappearing.
water.
Oh my God! What is happening? And it ends like, happens to me every time. Jesus Christ!
I don't know if
oh
the
my
state,
God.
if the court has seen the latest filing from the state.
I did see it.
Okay, so they filed a new expert disclosure on Monday from an expert who went through and analyzed the data at issue. So as
Response to the defense's
He's
having
fixing his
retained an
boots.
expert,
He's like, I got to go for a run after this.
discussed the whether or not you could exclude Mr. Kohberger from the DNA found under the fingernails.
Yes. And what triggered that was the grand jury testimony where questions were asked of the analyst regarding the meaning of a conclusive versus an inconclusive data result. And the analyst testified as to 13.1, the fingernail swabs, that their data was inconclusive. And to the defense, and that means that you cannot draw any conclusions. So the defense retained cybergenetics, which uses a different statistical tool than the lab here, and generated a statistic which is strongly exclusionary of Mr. Kohberger from that particular sample. And while that doesn't preclude the evidence from the state lab, it adds additional information to the picture, the overall picture, and
It's just a question for the experts to testify about and the jury to make its conclusion.
well, I think that allowing the type of questions and apparently now the new conclusion that was in the state's response to our motion would be inappropriate and prejudicial and should be excluded under and you have
Do
to.
you want me to believe your expert and not their expert?
No, I'm not asking you to believe any one in particular. However, what I am saying is that the amount of time and energy it will take to explain what inconclusive means is essentially far greater than should be the job of the defense to do.
I feel like she's going out a
Inconclusive
little
means
bit here.
inconclusive.
She's saying words.
No, I'm not saying that. I think it can be presented, and it can be presented in a fair manner that is consistent with due process and the right of Mr. Kohberger to confront it. The new disclosure from the
Troy's
state
just
is
watching his
an
life
expert who
flash
went
before
through
his
in
eyes
great
every
detail.
year.
We have a 27-page report from
He'll be
him
on death row for 20
where
years.
he not only
Not more.
reanalyzed the data visually, but he also used another statistical tool. And he stated in his conclusionary paragraphs, and it's a very long report, that first he looked at the data using the lab's protocols and doing some validation himself, essentially looking at their validation studies. And he found that just visual examination of the data excluded Mr. Kohberger. He went a step further and he said, I'm going to use this new third
Somebody's
tool
coughing
called
their head off
LR
in
Mix
here.
Studio to generate the same statistic
All right.
or similar statistic that the lab
Zombies
did,
plague's
the
about to
state lab
break out.
did, as well as
Or Brian's
True
hoping.
Allele Cybergenetics did in their analysis. And he came up with a strongly exclusionary statistic.
Brutal, Ola.
So we have now before the court, as he describes it in his disclosure, a statistic from the state lab, which means that it's 25 times less likely if the DNA originated. I always have a hard time with these numbers because you have to be extremely careful how you say this because it can flip the meaning. So let me just double check. His statistic, I'm sorry, I'll start with his. It's 5,000
This is kind of brutal.
to 100,000.
I mean, I'm not making fun of her at all, but I mean, you're Bryan Kohberger. You're sitting here watching this expert kind of go into this, portion of the case that is basically going to mean life or death for you, and they're stumbling along. Oh, I'm freaking the fuck out. I'm pissing my pants.
Times less probable that a coincidental match would be made to an unrelated person. In other words, what he's saying is that Mr. Kohberger is not included, and that's a strongly exclusionary statistic. And I'm not saying this very well, Your Honor, because it's these likelihood ratios are hard to
She's
explain.
me saying it, which is
so that's
the
a
worst at that
5,000
stuff.
to 100,000 times less probable that Mr.
Jen,
Kohberger
getting
is
somebody
present.
in here. Yo, Sheila Duffy getting with them sons of bitches. Hell yeah, all the way from Ireland. Thank you so much. Get them beers in the chat. Hell yeah.
My house.
That's what I'm talking about. We in here what?
Just chilling.
Chilling, hanging out. Shit. You know what? You know what we doing? Hold on. What happened to that one? Hold on.
You gotta fight for your right.
Don't forget, immediately after this, ladies and gentlemen, book club. I'm going to be going over here reading chapters. I'm going to be going over my notes from chapters 9 and 10 from The Stranger Beside Me. And then again, Friday night, Chris Duet and me are going to be watching a movie on Pre-420. And then on Saturday, 3 p.m. Eastern Time, Jay, Dandy Savage are going to be watching Grandma's Boy, 3 p.m. that day. Do not want to miss that, folks.
In other words, it's much more likely someone
Jen been
else
coming
is
through
there
tonight. Thank
if
you, Jen. I
there's
appreciate
someone else
that.
there. Then the
Jen's a G. Absolute G.
cybergenetics came up with a number that is in the range of 2.8 billion times less probable
Only 4 away from
that
a
he is there
Spansky.
than some other unrelated individual. And this expert then relates that even the state lab's number is 25 times less likely that Mr. Kohberger is there than some other unrelated person. So all of the numbers point to exclusion. The numbers, the question is really the weight of it. And the way that the state intends to present it, and they presented it in their reply to our motion, was they should be allowed to say that this means that Mr. Kohberger cannot be excluded.
Kick 3 in the
And
day
that
on
is just a
Saturday.
misrepresentation
Friday, I'm still not sure yet with Chris.
of their
We're gonna
own
be watching
data.
something
None of the
fun,
data
though.
that's presented to this court at this moment in this motion supports that statement or that conclusion. And it's unclear to me who is going to say that because it's not in any of the disclosures that have been produced so far. The first time we've seen it is in this reply brief. So I think that rather than having a battle of the experts, right, where you're going to have all 3 of these people testifying before the jury, and to allow that just one question is going to subsume an enormous amount of time in explaining why it's not in it, why it's inaccurate. And while it might be technically true, it's not an accurate statement for the jury to consider, and it's just going to confuse them. And it's highly prejudicial to Mr. Kohberger. So we would ask the court to, if it's going to allow this in, and we haven't asked to exclude the evidence, we simply asked the preclusion of this kind of questioning, that the state be precluded from inferring or asking a question to elicit some kind of inclusionary statement.
It'll be fun.
I hate these numbers.
Your Honor.
All right. I'm popping out. Oh, dude, we're gonna do that, Pammy. That's a good idea. We're gonna do Barbarian Queen, Lana Clarkson, sooner than later, actually. I'm tapping out on this right now. We're at 2:21. The next time I start this thing back up, if we keep on rocking through these, they're pretty interesting. Again, as we approach the Bryan Kohberger trial in August, unless anything changes. So yeah, what we're about to do right now, though, let me get the link in here if I can. If you're a member, you have the opportunity to come over and hang out in the Buzz Nation Book Club. We have a lot of fun. Again, I bring through, that's the wrong thing. I bring through a lot of notes that I take from the chapters that we read in this last week. Yes, actually today's when I listened to them. I read chapters 10 and 11. So yeah, we're cooking through this book right now. We're about a quarter of the way through. I think Madeline looked it up last time. So yeah, here's a share. Let me get this in here right now. Boom. Right there. There we go. All right. So yeah, come the fuck on, hang out. We're about to do that shit right now. And yeah. Hopefully you'll have a good time over there. Everybody else, I think there will be a show Thursday. I'm pretty sure. Probably 9-ish. I'm not sure. I don't know. Probably. But Friday night. Friday night you do not want to miss. Chris Stewart's coming through here. Chris is going to be hanging out. We're going to have a pre-420 show. And then, of course, Saturday, 3 in the day with Jay. My dude Jay. First time coming through in a long time. And then Dandy Savage for Grandma's Boy. We're going to be watching that on Kick. But yeah, thanks everyone for coming through. Right now, I just now put the link in the chat. That is the doorway to the book club, the Buzz Nation Book Club. Got Jersey Jen coming through here being a motherfucking G. Always. Pokemon coming through and modding up tonight. I really appreciate that. Thank you, Shelly. What's up, Jeff? How you doing, bud? But yeah, it's gonna be fun. I'm excited to have Jay on here. I'm excited because it's the holiday. And the movie should go right through an actual 420. So there is that. It's going to be pretty fucking rad. But yeah. All right, guys. Let's get the hell out of here. Thank y'all so much. We'll keep, probably doing some more Kohberger stuff. Leading again till the trial. Thank y'all. Let's go. Boom. Show up. I want to see you over there. And I probably won't even be 5 minutes. I don't even think I got to use the bathroom. I'm ready to rock. Let's go.